And they further state that Clause 5, paragraph A should be amended as follows. Where two or more different systems of customary law may be applicable in a dispute before the traditional court, the traditional court must apply the system of customary law at the presiding officer, who will be the traditional leader. And we respond to both submissions by stating that it is important to note that the bill is not mirrored on Botswana's traditional court system. The traditional justice system uses a different value system to the conventional system. And the bill is not intended to change the way traditional courts function, but to align their functions with the constitution. Regarding just a follow-up submission, with the department's response is that the proposal is not supported, as it will be imposing a system that is foreign to the parties, thereby severely violating their rights as parties. A follow-up submission. Bumalanga Provincial Legislature made the following submission that Clause 5, Subsection 3, Paragraph B should be amended to require National House of Traditional Leaders to also report to Parliament each year, report on the participation of women and the promotion of gender equality in traditional court, and may, to this end, make recommendations on legislative and other measures. And the department's response is that the Commission for Gender Equality is better placed to report to Parliament, as it has the mandate to promote gender equality. In making the report, the Commission for Gender Equality will by all means need the input of National House of Traditional Leaders. When legislation is prepared, the National House will be consulted as a matter of course and all specified by the rules of Parliament. They further make a submission to the effect that Clause 5, Subsection 4 should be amended to provide for the clerk of the traditional court to be appointed after consultation with the Provincial House of Traditional Leaders, appointed, designated from traditional council concerned, and for the clerk of the court to be capacitated after the act has been enacted for them to perform their duties efficiently. The current staff of traditional institutions should be given preference during the appointment process. And the department's response to that is that the clerk of the traditional court will be appointed, designated, or seconded in accordance with the law governing public service. As such, it will not be possible that they are appointed after consultation with the Provincial House of Traditional Leaders, as the clerk of court will be public service officials and appointed in terms of the regulations governing appointments in public service. Clause 6, which deals with nature of traditional courts, in that one, the Gauteng Legislature made the following submission that the status of traditional courts should be the same as that of judicial courts, where some powers are exercised. And the department's response to that is that Clause 6 of the bill outlines the nature of traditional courts. These courts are courts of law, the purpose of which is to promote equitable, fair resolution of certain disputes in a manner that is underpinned by the value system applicable in customary law and custom, subject to the Constitution. Section 34 of the Constitution recognizes that everyone has the right to have any dispute that can be resolved by the application of the law decided in a fair public hearing before a court, or where appropriate, another independent and impartial tribunal or forum. Traditional courts qualify for classification under this section, so they are recognized in the Constitution. These courts are also recognized under Item 16 of Schedule 6 of the Constitution. What is of importance is the nature of these courts. And the Limpopo Legislature make a submission to the effect that amend this clause by adding the following words. Traditional courts should create enabling environment to community members' successful resolution of conflicts. And the department's response is that the bill already does this in Clause 3, containing guiding principles, and in Clause 7, dealing with procedure in the court. KwaZulu-Natal Provincial Parliament made the submission that safety at traditional courts is a huge concern. And the department's response to that is that security of members of the court should not be a concern because the bill is premised on restorative justice. and the cooperation of parties is of importance as they choose to use the system to resolve their disputes. Because the traditional court mediates between parties, this by its nature makes the appearance at the court voluntary. This is due to the fact that the court apply restorative justice methods aimed at restoring the relations between parties, maintenance of peace and social cohesion. They further make a submission to the effect that an addition should be inserted in the bill which deals with appeals from the decisions of the traditional courts with leave of traditional courts. Clause 6, capital A, powers of the King or Queen's Court in hearing appeals. Clause 6, capital A, subsection 1, the King or the Queen's Court exercising appeal jurisdiction may hear, determine appeals from traditional courts, receive further evidence, remit the matter or the case to the traditional court whose decision is subject to the appeal for further hearing with such instruction as regards the taking of further evidence, otherwise as the King or the Queen's Court deems necessary, and confirm, amend, or set aside the decision which is the subject of the appeal and make any decision which the circumstances may require. They further say that Clause 6, capital A, subsection 2, other disputes the King or the Queen's Court may have jurisdiction on. The King or the Queen's Court exercising jurisdiction may, in addition to any power as may specifically be provided for in this Act or in any other law, hear or determine disputes arising from traditional law and custom referred to it by an individual, the Premier, or the MEC responsible for traditional affairs for consideration over traditional leadership, boundaries between traditional communities with a particular kinship or queenship concern, succession or inheritance, payment or return of lobol, or related altercation between members of traditional leadership, damages for seduction, witchcraft, defamation of character. And the department's response to that effect is that the bill is pitched at the level of the court of traditional leader. As the bill does not aim to change customary law, the King or the Queen's Court should be able to deal with appeals the way they have been. It's not known whether the proposal covers the handling of appeals by kings and queens in all communities where they exist, or whether there are any disparities, in which case there must be a comprehensive consultation. As for other disputes that the King or the Queen's Court may have jurisdiction on, it is not clear where such a court will be a court of first instance in respect of these matters. The department then is of the view that if the King's Court will be the court of first instance, then the provision will be misplaced in the bill and that they could be best dealt with in its own piece of legislation because the bill does not cover the proposed scope. Bumalanga Provincial Legislature's submission is that the bill must accommodate the hierarchy of traditional institutions for dealing with cases and appeals. And the department's response to that is that as the bill does not aim to change the customary law and also recognize the levels of traditional leadership, the bill does not preclude the courts from operating the way they have been, other than to align their function with the values of the Constitution. They further suggest that the court of a principal leader must be provided for in Clause 6, subsection 3 of the bill by insertion of the levels court of a principal traditional leader. And the department's response to that is that the levels of traditional leadership as stated in the bill are levels as they existed in the Traditional Leadership and Governance Framework of 2004 at the time of drafting of the bill. The Traditional and Quiescent Leadership Act now provides for this level, and therefore the department has no objection to revising Clause 6 in order to recognize the level of principal traditional leader. Clause 7, which deals with procedure in traditional courts. And in that, the Eastern Cape Provincial Legislature made the following submission, that legal representation in traditional courts is required. And the department's response to that effect, is that the retention of the purist character of the traditional justice system obviates the need for legal representation, which is unsuited for this for dispute resolution in the traditional justice system. A person in the traditional court may be represented by any person of his or her choice as provided for in clause 7 subsection 4 paragraph A. Traditional courts provide for easy access to justice because of their proximity to communities and are cost-effective, cheaper, and offer speedy resolution of disputes. The expeditious nature of these courts can be frustrated by protracted legal arguments, which will also diminish the simplicity and flexibility of this system. Affordability and the need for interpretation services can also complicate the functioning of these courts if legal representation is allowed. A view is held that legal representation is unsuited to the system. It has been argued that the disputes that are brought to these courts are simple and do not need the complicated legal arguments. This is not unique to this system, as legal representation is not permitted in the small claims court, for example. It is critical that the dynamism of the system is maintained for the benefit of those who use it. The Limpopo Legislature made a submission to the effect that there is need for legal representation in the courts for fair decision of cases so that the court's rulings can be appealed. And in addition to the previous department's response to the issue of legal representation raised by the Eastern Cape Provincial Legislature, we further add to that by stating that a person can still escalate their matter to the magistrate court in terms of clause 12 after exhausting all traditional court system appeal procedures available in terms of customary law, as contemplated in clause 6, subsection 3 of the bill. The added benefit is that magistrates will hear the matter afresh. Free State Legislature made their submission to the effect that prohibition of legal representation is in conflict with the right to a fair trial and administration of justice. And the department's response is that there will be no trial in the traditional courts, as the traditional justice system is restorative in nature. The operation of the traditional courts needs to be differentiated from that of conventional courts, as even a person against whom a complaint is made is assisted by the court. KwaZulu-Natal Provincial Parliament comments that legal representation in the traditional court system should be allowed so that parties can have a fair hearing. And in addition to our responses to the previous submissions, we're saying, in addition, allowing for legal representation in traditional courts will be costly. It will burden the courts with unusual legal technicalities, which will prolong the proceedings and impede access to justice. Northwest Provincial Legislature made their submissions regarding legal representation by stating that prohibition of legal representation is not supported. And the department states that a party can be represented by any person of his or her choice, as highlighted in section 7, subsection 4, paragraph A in the bill. The use of legal practitioners will take away the benefits of speedy, cheap, and accessible system. Northwest Provincial Legislature further makes a submission to the effect that women and children must be empowered and afforded opportunities in the proceedings of traditional courts. And the department's response is that the bill in section 5, subsection 3, paragraph A, subparagraph 2 provides for measures to be put in place in order to protect vulnerable persons, the representation and participation of women. The bill requires the Commission for Gender Equality to report to Parliament on the participation of women and the promotion of gender equality in traditional courts. The bill also envisages a role of paralegals and interns in the traditional courts. These officials will be instrumental in ensuring that the traditional courts are made aware of the rights of persons with vulnerabilities and how these courts should deal with such persons. The Western Cape Provincial Parliament made a submission to the effect that clause 7, subsection 6 and subsection 8 are inconsistent with legislation that protects the rights of children to testify in Canberra. And the department's response is that Clause 7 requires the court to take vulnerabilities of persons, including children, into consideration when applying the bill. The bill also envisages a role for paralegals and interns in traditional courts, who will be able to assist and guide the court when it deals with children. The persons who implement the bill will also be trained in the rights of persons with vulnerabilities, including children. A view is held that children will be better off when their problematic conduct is dealt with in the traditional court, so that they do not acquire criminal records early in their youth, and their conduct can better be corrected in the traditional court. Clause 8 deals with orders that may be made, and how the legislature made the following submission: that the consent of both parties should be obtained before an order to perform services in lieu of compensations is ordered. And the department's response is that this is what the bill aims to achieve through social cohesion and applying restorative justice. And KwaZulu-Natal Provincial Parliament make a submission to the effect that the bill should allow imposition of fines, as this may serve as a deterrent. In order to avoid abuse, amounts that can be imposed as fines should be regulated. And the response by the department is to the effect that because the traditional justice system is essentially about promoting restorative justice and social cohesion, and imposition of punitive sanctions such as fines vitiates the nature of traditional courts. Western Cape Provincial Legislature made a submission to the effect that fees payable to traditional courts will create an opportunity for corruption and might limit access to justice for those unable to pay. And the department's response is that it has been argued that fees of traditional courts will be very minimal. The regulations will further provide more detail on how fees must be dealt with. Bumalanga Provincial Legislature made a submission that corporal punishment, banishment, cruel and inhuman and degrading punishment should be explicitly excluded from the permissible orders listed in Clause 8 of the bill. And the department responds by stating that these are not provided for as orders that the court may make under the bill. They further state that consent of both parties should be required before any order to perform services in lieu of compensation can be granted. In other words, in respect of both clauses 8 subsection 1 paragraphs B and C. And then the department's response is that the bill is premised on restorative justice and maintenance of harmony in communities. Consent of the parties is a basic tenet of restorative justice. And the legislature further states that traditional courts should be able to grant the orders listed in paragraphs A to C of Clause 8, subsection 1, in favor of any party to the dispute, as with other orders listed in Clause 8, not just in favor of the person who institutes proceedings. And the department's response to that is that the aim of these orders is to restore the person who suffered the loss to the position that they were in before the loss. It is specifically for the damage suffered. This is in order to mitigate the complainant's loss. And they further made a submission that Clause 8, subsection 1 lists the type of orders that may be made after deliberating on a dispute before it. The section refers to orders made in terms of monetary loss or otherwise, including loss of livestock. However, the phrase proven financial loss does not provide any guidance on how it may be proved. We would like clarity on what factors are to be taken into account and whether experts will be allowed in the traditional courts. And the department's response to that is that disputes which the traditional courts may deal with are not the type that will require experts to prove. The loss can be proven in any way of presenting evidence, such as presentation of receipts or witnesses called to appear before the court. And Bumalanga Provincial Legislature further makes a submission that traditional courts can also make orders directing a party who cannot provide financial compensation to perform without remuneration some form of service to the offended party per paragraph 8, subsection 1, paragraph C. This section is highly problematic and an infringement of section 13 of the Constitution, which prohibits servitude and forced labor. And the department's response to this is that this will be based on consent in order to achieve restorative justice. This is a known order at customary law. Above all, parties consent to the order. They further make a submission to the effect that clause 8, subsection 1, paragraph D allows for an order prohibiting conduct complained of or directing that specific steps be taken to stop or address the conduct being complained of. This power is functionally equivalent to forcing specific performance without an alternative for payment of damages within the meaning of section 46, subsection 2, paragraph C of the Magistrates Courts Act of 1944. This provision appears to grant traditional courts powers beyond that of the Magistrate Court. And the department's response to this is that these are customary law orders which are considered to foster peacemaking between the parties. This will be based on consent in order to achieve restorative justice. This is equivalent to a reprimand. They further make a submission that clause 8, subsection 1, in paragraph H allows for an order that a party attends any form of training, orientation, or rehabilitation that is consistent with relevant customary law, the Constitution, and this Act, and does not include any form of detention or deprivation of any customary law benefits. It is unclear how the cost of training, orientation, or rehabilitation will be covered. Is it provided by the offending party, traditional court? And the department's response to that is that this will be covered by the party against whom a complaint is made. The rehabilitation will also be beneficial to the offending party. It cannot be expected that the traditional court will have funds to cover such an expense, if any. This may even not involve any expenses, as it may be in the form of the peers of the offending party giving him or her lessons. The legislature further comments in clause 8, subsection 1, subparagraph 1, allows for an order requiring any party to the dispute to make regular progress reports to the traditional courts regarding compliance with any condition imposed by the traditional court. This provision raises the question of whether traditional courts will be or should be allowed to grant structural interdicts in the form of supervisory orders. And the department's response to that is that it is important to note that customary law does not have the strict formalities. All the parties will be interested in the resolution of the dispute and the realization of peace and harmony. This has been done in the court and can take the form of an oral report. Northern Cape Hanesep made their submission to the effect that clause 8, subsection 1, paragraph A, subparagraph 4, the clause is not acceptable because all bodies or organizations will be connected to a member of the traditional court or the traditional leader, as the community members appearing in the court will be either direct or extended family members. And the response to that is that clause 7, subsection 12 deals with conflict of interest, and a member of the court must declare their interest in the matter before court and, where appropriate, must withdraw from participating in a matter. They further make a submission to the effect that clause 8, subsection 1, paragraph C, subparagraph 2 provides that no service whatsoever. This clause is unacceptable because the traditional leader or his or a family, or to any person acting in an official capacity in that traditional court, will be family as well as the community will be members of extended greater family. And we will respond in a similar way as I did earlier on in paragraph A. And they further make a submission that clause 8, subsection 3 must be amended as follows. A traditional court may order that any payment contemplated in subsection 1 or part thereof be paid to a person injured by an act or omission for which the payment was imposed unconditionally, and may bring an action in any court in order to recover damages for injury he or she sustained. And then the department's response to this is that this will be unfair, as it will be amounting to punishing a party twice for the same act or omission. This is not permitted by rules of natural justice. If the traditional court resolves a matter, a party cannot take the same resolved matter to another court to be processed again. Clause 9 deals with enforcement of orders, and the Gauteng legislature made a submission to the effect that the enforcement procedure in clause 9, subsection 4 of the bill should be clarified, preferably to align it with a procedure contained in clause 4, subsection 4. And the department's response to that is that clause 4, subsection 4 and clauses 4, subsection 4 and 9 and subsection 4 give guidance on enforcement procedure to be followed. The clerk of the court will refer the issue of non-compliance to peace officer, who will then deal with the matter in terms of processes available under the Justice of the Peace and Commissions Oath of 1960, Oath Act of 1963. The Limpopo legislature made a proposal that permitting appeals to the magistrate courts will result in traditional courts being undermined. And our response to that is that the referral of a matter to the magistrate's court under clause 12 is necessary as a building safeguard in respect of protection of rights of an individual. This provision is necessary, especially where a party who did not want to appear in a traditional court was not given an option not to, and they feel that their matter was not dealt with fairly and to their satisfaction. KwaZulu-Natal Provincial Parliament commented that it's not clear how enforcement of orders will be dealt with, especially where there is non-compliance due to the courts being undermined. And the department's response is that the bill provides for the scenario where a party who, after being summoned to appear in a traditional court, willfully fail to so appear in clear contempt of court. The clerk of the court must make a determination to this effect and then refer the matter to a justice of the peace. Clauses 4 and 9, 4 subsection 4 and 9 subsection 4 outline the procedure to be followed in enforcing compliance with the orders of a traditional court. Clause 10 deals with provincial traditional court registrars, and Bumalanga Provincial Legislature is of the view that in order to ensure that matters before traditional court are treated with necessary agency and professionalism that requires, the following insertion is proposed. They propose that the new position will ensure that all districts have regional registrar who will report to provincial registrar. The duties of the regional registrar should, amongst others, review the recommendation of all matters that must be reviewed by the High Court. The regional registrar should study all matters that were decided by traditional court and advise the provincial registrar accordingly on those issues to be referred to the High Court. The regional registrar would be appointed in the same manner as the provincial registrar. And the department's response to that is that the issue of personnel in the office of provincial registrar could be looked into once an evaluation of the work is done. The registrar will have personnel assisting him, but a determination of that could be done at a later stage by the provincial registrar himself or herself. The legislature further make a submission to the effect that traditional court registrars will be legally trained and qualified if they will be assisted by a court clerk or otherwise. Determination should be made by someone with legal training, and a traditional legal member of the traditional council would not necessarily be qualified to do so. Once referred, it is not clear whether normal magistrate court procedures will be followed. If so, who will represent the parties and who will pay for that representation? And the department's response to that is that one function of the registrar is to be able to guide and supervise the court. Clause 14, subsection 1, paragraph B provides that if the matter is transferred to the magistrate's court, the magistrate's court must commence the proceedings afresh, thus applying the rules of procedure applicable in that court. If a party needs legal representation, such a party will apply for legal aid as a matter of course in the proceedings in the magistrate's court. Clause 11 deals with a review by the High Court, and how the legislature made a submission to the effect that the bill should provide for legal aid where persons want to file for a review. It is submitted that nothing precludes a person who wants to have a matter reviewed to apply for legal aid. Limpopo Legislature is of the view that there is no need for the bill to provide for review process because there will be no cost implications in the adjudication of cases in traditional courts. And traditional leaders would have been provided with training. The involvement of the High Court is not necessary. And the department's response to that is that the provision offers a remedy in instances where a party to any proceedings in a traditional court is aggrieved by the manner in which proceedings were carried out. It will assist in developing the jurisprudence relating to customary law. The right to have a decision reviewed is a constitutional right and cannot be excluded. And the Western Cape Provincial Parliament submission is to the effect that it is proposed that grounds for review be expanded to include all matters pertaining to the application of formal and procedural law proceedings. And the department's response to that is that a review has a very specific purpose in law, which is for another court to consider whether there were procedural shortcomings in dealing with the matter. Northern Cape, HANESEB submissions are that Clause 7, Subsection 6 be amended as follows. The proceedings of the traditional court were not open to all members of the extended Greater community. And the department's response to that is that it is difficult for the department to make an informed decision without the information of why the court should not be open to all members of the community and which members of the communities will not be allowed in the court and under what circumstances. The bill will be a law of general application. It cannot have a provision preventing other people not to access it. Concerns have been raised in the past of women being prevented from accessing the court in certain communities, which cannot be permitted. Bumalanga Provincial Legislature submission is to the effect that the bill should put in place an access provision that grants persons access to legal aid if they want to bring a review in terms of Clause 11. And the department's response to that is that nothing precludes a person who wants to have a matter reviewed to apply for legal aid. They further make a submission to the effect that the grounds of review are limited and as they are primarily procedural. Key grounds of review, such as suspected bias, are absent from the enumerated list. And the department's response is that legally, matters are taken on review only on grounds of procedural deficiencies. The last ground in the bill on which matters may be taken on review is a catch-all phrase, which will cover any procedural shortcoming, even those listed in the bill. They further make a proposal that an opting out mechanism is a minimum requirement for ensuring that traditional court bill complies with the rights and freedoms set out in the Constitution and customary law. To be consistent with the consensual nature of customary law, the bill should preferably be reconfigured to require that both parties expressly opt in. And the department's response to that is that the right to opt out of the traditional justice system was removed from the bill in the portfolio committee. And in order to give parties some protection, Clause 12 was then inserted in the bill. This clause provides for the right of a party aggrieved by any decision or order of traditional court to refer a matter to the magistrate's court after exhausting all traditional court justice system appeal procedures. The magistrate's court may give any order or decision it deems competent to give. The legislature further made a submission to the effect that the bill must furthermore impose an explicit duty on the clerk of a traditional court to inform all parties who are summoned to court and also who bring cases to the court that it is their choice whether to participate in proceedings. And the department's response is that the duties of the clerk of a traditional court, as highlighted in clause 5, subsection 4, paragraph B of the bill, are mainly administrative in nature. The clerk of the court will be acting outside the confines of the bill, as the bill does not provide for parties to elect whether to attend a court or not. A safeguard mechanism is contained in clauses 11 and 12 of the bill that will ensure added protection to the rights of participants in the traditional court. And they further make a submission to the effect that where an opt-out mechanism is included, grounds for review should be added in clause 11 to address situations where a person's right to opt out has been impeded or denied. The clerk fails to inform any party of the right to opt out of the traditional court proceedings, or a person has experienced intimidation, manipulation, threats, or denigration for trying to opt out. And the department's response is that the bill does not provide for the right to opt out of the system, so this cannot be a ground for review. The ground relating to the conduct of the court where a person has been intimidated is covered in paragraph or clause 11, subsection 1, paragraph M. Clause 12 deals with referral of matters. And the Eastern Cape Provincial Legislature made a submission to the effect that the bill should provide for an appeal structure within the traditional justice system so that referral of cases to the magistrates court is avoided. And the department's response to that is that the bill in clause 12, subsection 1 does not prohibit parties from escalating matters to different levels of the traditional court system as they exist at customary law before approaching the magistrates court. This is a constitutional right which cannot be denied to a party that feels that their rights are infringed. Western Cape Provincial Legislature made a submission to the effect that requirement that a compelling reason must exist before a matter will be allowed to be withdrawn or abandoned is unconstitutional. And the department is of the view that the bill does not contain such a provision. And the bill contains schedules 1 and 2, which help in determining matters that can be heard or not in the traditional courts. And the legislature further comment that the bill should provide for an appeal process. And the department's response is that clause 12, subsection 1 provides for referral of matters from the traditional courts to the magistrates court, effectively, which is an appeal process. An aggrieved party can refer the matter to the magistrate court under this clause. KwaZulu-Natal Provincial Parliament proposes an amendment of a clause as follows, that a party aggrieved by a decision or order of a traditional court on grounds other than those referred to in section 11, subsection 1, may, after exhausting all traditional court system appeal procedures available in terms of customary law in section 6, subsection 3, where the envisaged traditional appeal process exists, refer that decision or order to the magistrate court having jurisdiction in a prescribed manner and period. And the department's response to that is that clause 6 already recognizes the level of traditional justice system as they may be available in certain communities. As the bill does not aim to change customary law, the communities where kings and queens exist will continue to use the levels as they know them to exist in their areas. The fact that clause references, the fact that clause 6 subsection 3 make references to that suffices, including that the clause itself mentions kings and queens where they are available. The Limpopo legislature submission is that the bill must provide for the establishment of appeal procedures in senior traditional leaders' jurisdiction. There must be a structure that looks into appeals so that by all means, magistrates' courts are avoided. And the department's response to that is that as the bill does not aim to change customary law, the courts should be able to deal with appeals the way they've been. The referral to magistrates' courts cannot be avoided as parties have the right to have their dispute adjudicated by any court. Free State legislature is of the view that clause 12 of the bill allows for referral of matters from the traditional court to the magistrates court by an aggrieved party, but only after the party in question has exhausted all traditional court appeal procedures available in terms of customary law. The magistrates court's alternative is costly and can further frustrate the aggrieved party who never wanted to be part of this system in the first place. This is in contravention of clause 3, which states that a founding value of customary law is that its application is accessible to those persons who voluntarily subject themselves to that set of laws and customs. Persons should not be permitted to opt out of the traditional court system. And the department's response to this is that this provision will be beneficial to a party who never wanted their matter to be dealt with in the traditional court, but could not make that choice. Such a person will be able to have another forum to adjudicate the matter if they are aggrieved by the decision or order of the traditional court. Bumalanga Provincial Legislature submission is to the effect that any order of the traditional court in terms of the Act must be reviewable by the magistrates court, even if all traditional court system procedures have not been exhausted. The court may then confirm such an order in whole or in part, set aside such an order in whole or in part, substitute such order in whole or in part, and remit the case to the traditional court with directions to deal with any matter in such a manner as the magistrates court may think fit, taking into account the tradition and customary law practiced in the area. And the department's response is that a review must be carried out after the conclusion of the matter. This bill is picked at the level of the court of a traditional leader. So dispute resolution at other levels, such as headman level, will not result in review, but only if an order is made at the level of traditional court level. Dispute resolution at other level is not regulated in terms of this bill, and thus parties are not precluded from taking their disputes to those levels. It is also possible for a party to take their matter directly to the traditional court without having started at other levels. It is important to know that resolution of dispute in terms of customary law is to prevent conflict and maintain harmony using restorative justice. The parties need to be sensitized about this when bringing matters to the traditional court. The legislature further submit that in each traditional court, there must be assessors who are legally qualified to ensure that the rights contained in the Bill of Rights are not transgressed in the course of traditional proceedings. And the department's response to that is that it has been emphasized that in a traditional court, a traditional leader does not operate like a judicial officer in a conventional court deciding cases, and that he or she acts in concert with other people. It has been pointed out that even other people in the court make a contribution to the proceedings. Based on this, a traditional court system does not lend itself to the use of assessors. The members of the court will be trained on the application of the bill. The Bill of Rights is one of the important area where they will need to be trained. Regulations to this effect will provide more detail on the content of training. The legislature further made a submission that the bill, as introduced into Parliament, provided for the right of persons to be able to opt out of the traditional justice system. This provision has now been deleted from the bill, and this presents serious problems. The deletion of this provision undermines the voluntary nature of customary law and creates a mandatory second-tier system of law for those residing in traditional communities. And the department's response to that is that the right to opt out of the traditional justice system was removed from the bill in the Portfolio Committee. However, in order to give parties some protection, Clause 12 was inserted in the bill, and this clause provides for the right for a party aggrieved by the decision or order of a traditional court to refer a matter to the magistrate court after exhausting all traditional justice system appeal procedures. The Magistrates Court may then give an order or decision it deems competent to give. Clause 13 deals with recording of proceedings. And the Limpopo Legislature made a submission to the effect that Clause 13, Subsection 1, Paragraph H, related to the taking of pledge must be deleted from the bill. And the response to the department, the response from the department is that the saying of the pledge is necessary in order. Let me start again. The saying of the pledge is necessary in order as it has the effect of taking an oath of office. Other options such as taking the oath were considered but found to be impracticable, as an oath has to be taken before a commissioner of oath, and this seemed impracticable. As members of the court change frequently, the saying of the pledge is necessary for whoever applies the provisions of the bill to be reminded that they need to comply with the provisions. Clause 14 deals with the transfer of disputes, and the Western Cape Provincial Legislature made a submission to the effect that there are no mechanisms in the bill to guide and monitor relationship between traditional courts and SAPS. And the department's response is that there should be no involvement of the police in traditional courts, as these courts are premised on restorative justice. Nothing precludes the court from summoning the police if a crime is committed and the court does not have jurisdiction. Bumalanga Provincial Legislature is of the view that Clause 14, Subsection 1, Paragraph A states that if a traditional court is of the opinion that a dispute before it is not a matter which it is competent to deal with, as contemplated in Section 4, or if the matter involves difficult or complex questions of law or fact that could be dealt with in a magistrate's court or small claims court, or if it is a matter as contemplated in Section 4, Subsection 4, Paragraph B, Subparagraph 2, or Section 9, Subsection 4, Paragraph B, Subparagraph 2 of the Traditional Court of the bill, the traditional court may, in the prescribed manner, transfer such dispute to the magistrate court or small claims court having jurisdiction and notify the parties to the dispute of the transfer. This determination should be made by someone with legal training, and a traditional leader or member of the traditional council would not necessarily be qualified to do so. And the department's response to that is that the court has a schedule which contains a list of disputes that the traditional courts may deal with, and this should guide the court in determining matters they may need to refer. Also, one of the functions of the traditional court registrar is to guide and supervise the courts. Therefore, where a court is in doubt, the registrar will be of assistance to it. They further made a submission that it is not clear whether once referred, normal magistrate court procedures would be followed. And the response is that Clause 14, Subsection 1, Paragraph B provides that if a matter is transferred to the magistrate's court, the magistrate's court must commence the proceedings afresh, thus applying the rules of procedure applicable in that court. If a party needs legal representation, such party will apply for legal aid as a matter of course in proceedings in the magistrate's court. Clause 15 deals with limitation of liability, and Limpopo Legislature submits that limitation of liability should be substituted with indemnity. And the department's response to that is that the bill absolves members of the traditional courts from liability in the case of anything done in good faith. This excludes anything done in bad faith. The bill provides a form of limitation of liability and not indemnity as an accountability measure. Clause 16 deals with code of conduct, and Gauteng Legislature is of the view that Clause 16, Subsection 1 must be amended to require the minister to consult with ordinary people about the content of the code of conduct. And the department's response to that is that ordinarily regulations as subordinate as subordinate legislation and the content thereof are consulted on with interested parties who include members of the public. Northwest Provincial Legislature submission is that the bill should provide for the screening or vetting of those who are going to preside over traditional court proceedings so that persons who have criminal records can be excluded from presiding in traditional courts. And that is department's response to that is that traditional leaders preside in traditional court because of their recognition as such under the Traditional Leadership and Governance Framework Act. Furthermore, there are processes under this act to deal with a traditional leader who has made himself or herself guilty of misconduct. The code of conduct will not only apply to traditional leaders, but also to persons who have a role to play in the traditional court. So the provision is even broader than as proposed. Eastern Cape Provincial Legislature submission is that in clauses 16 subsection 1 paragraph A and clause 16 subsection 2 and 17, we should substitute the words after consultation with in consultation. And our response to that is that clause 16 subsection 1 paragraph A and subsection 2 state that the compilation of the code and periodic review thereof must take place in consultation with the functionaries responsible. The input of relevant functionaries on the content of the code of conduct, hence it will be critical that the provision is worded in a manner, hence it's critical that the provision is worded in this manner. However, with regards to clause 17 subsection 2, the making of regulation is the function of the minister, which he or she is obliged to carry out. Requiring a minister to only make regulations after consultation will likely hamstring and delay the process, especially if cooperation from other functionaries is not adequate. The regulations are necessary to put the bill into operation, hence it suffices to require that the minister is consulted on the regulations. Bumalanga Provincial Legislature submission is to the effect that ordinary people are best placed to comment on the kinds of abuses that are sought to be prevented by the Code of Conduct. Therefore, clause 16 subsection 1 should be amended to require the minister to also consult with ordinary people about the content of the Code of Conduct. The Code of Conduct is aimed at regulating and guiding the conduct of the persons who will be implementing the bill, and that's the department's response. In addition, the consultation is normally is carried out with the role players who will be directly affected by the instrument consulted on, that is the code. Whether the public is consulted on the code or not, it should be accessible to whoever wants to know its content and see whether the conduct of a person in line with the code is in line with the code. Code normally resides with the institution whom it is intended to govern. Even with the primary legislators, there is not a provision in specific acts that the general public must be consulted. The consultation happens as a matter of course. Based on this, the proposal is not supported. And they further make a submission that the responsibility for the enforcement of the Code of Conduct in terms of clause 16 subsection 5 and 6 should remain with the provincial MECs as originally provided for in the bill as introduced. And the department's response is that the proposal is noted and the requirement that the breach of the code be reported to the MEC responsible for traditional affairs in specific province was substituted for the institution of traditional leadership by the portfolio committee. The Northern Cape Provincial Legislature's submission is that the amount of compensation in clause 16 must be clearly specified. And the department's response is that specifying the amount of compensation in primary legislation or at all will be problematic since the legislation will require to be changed every time the amount changes. The other reason, which is the main one, is that Compensation is linked to damage suffered, so there is no need to specify the amount of compensation payable since it determines itself, although the court can adjust it to what is fair and equitable depending on the facts of the dispute. They further make a submission to the effect that the bill does not indicate if the Khosi and the Khosana will also be subjected to the proposed disciplinary actions. And the department's of the view that the bill provides for the code of conduct to apply to every member of the traditional court. Clause 17 deals with regulations, and Limpopo Legislature's submission in that regard is to the effect that the bill must provide for a minimum of 5 persons per traditional council to be identified for training. And the department's response is that the bill does not envisage a traditional council being a traditional court. This is largely because the composition requirements differ as well as the function of the two institutions. However, every person who applies the provisions of the bill is required to be trained as provided for in the bill. Clause 18 deals with transitional provisions, and the KwaZulu-Natal Provincial Parliament made the submission to the following, that the following must be inserted in the bill. They are of the view that Clause 18, subsection 2, capital A, be inserted to read as follows: all matters or cases that were dealt with under Section 12 and 20 of the Black Administration Act of 1927 by a traditional leader before the commencement of this act shall be regarded as valid. And then the department's response to that is that there is no need to include such provision in the bill since finalized cases are not covered in the bill. They are final and can only be dealt with in terms of the law that was applicable to them by the time they were finalized. They are finalized matters and can only be reviewed in terms of the law under which they were finalized. And then we've got scheduled to the bill. And the Northern Cape Provincial Legislature's submission in that regard is that monetary jurisdiction of 15,000 should be increased so as to enable the courts to deal with stock theft. And then the department's response to that is that the bill aims to empower traditional courts to only deal with minor disputes, which may not warrant a person acquiring a criminal record. There are specific penalties for stock theft, which a traditional court may not impose. Offenses such as stock theft are complex, and a full investigation by police may be required, and offenders, if convicted, are to be harshly dealt with. This may not be possible in the traditional court. How the legislature's submissions in this regard that monetary jurisdiction of 15,000 should be increased in order to enable the courts to deal with more serious offenses. And the department's response to that is that the bill aims to only deal with minor disputes, which may not warrant a person acquiring a criminal record. Capacity constraint may not enable the traditional court to deal with serious cases, as such cases may require investigation by the police, and for persons, if found guilty of the offense, to have a record of that offense registered against their name, which may not be possible in the traditional court. The threshold was initially set at 5,000 rands following consultations on the bill, and it has since been increased to 15,000 rand. Western Cape Provincial Legislature submission is to the effect that the court has a jurisdiction to hear matters pertaining to ukutwala, initiation, custody, and guardianship, which is inconsistent with the Constitution. And the department's response is that the bill does not allow the court to deal with ukutwala, but the court can give advice and opinion to courts when they are adjudicating cases involving ukutwala, initiation, custody or guardianship, maintenance, and other customary law practices. This would be similar to expert evidence. There is already a precedent in our court systems on that, and it's that of Jezile versus the state, which was held in the Western Cape in 2015, which related to ukutwala. The court requested an opinion on the correct practice of this cultural practice. And this shows that it is legally permissible. General comments. How the legislatures...
Mr. Mangena, let me stop you there. Thank you very much. I think the general comments, a lot of your responses, you've already covered it in terms of what you've already presented. And you've covered all the clauses of the bill. I'm going to first give the parliamentary legal advisor, Bumalanga Ngema, to make a presentation to the committee as well. Bumalanga.
Thank you.
Thank you, Chairperson. Greetings to all the members and everybody present for this meeting. Chairperson, I will take, I think, about six matters that I just want to either substantiate or supplement in what the department has already presented. And it's just to clarify, Chairperson, some of those issues that they've already spoken to. The first one, Chairperson, I think it's the one that seeks to explain the status of the courts. Firstly, I think it's important to recognize and realize that Chapter 12 of the Constitution, especially Section 211, Sub 3, status of the courts, the Constitution, I think, appreciates that they are already in existence. So this bill does not necessarily seek to establish them afresh. It seeks to regulate what is already in place, but gives legal certainty that is necessary. Section 211(3) of the Constitution, just to repeat it, it says the courts must apply customary law when that law is applicable, subject to the Constitution and any legislation that specifically deals with customary law. So both customary law and customary courts, they are recognized as a legal system within our pluralist legal system that is in South Africa and in light of the Constitution being the supreme law of the country. Now, Chairperson, that said, I think it's also, even though it may not be explicit, but it is clear that the intention of this bill does not necessarily seek to locate the traditional courts under Chapter 8, which deals with the judiciary. And even though the certification judgment did indicate that when the Constitutional Court dealt with the certification of the constitutional provisions, it did indicate that traditional courts may be able to fall within Section 166E of the Constitution as any other court that is established and regulated in terms of national legislation. But it is very implicit in the details of this bill that what is intended is that this structure or these courts, they become a Section 34 structure or forum, which facilitates or becomes some form of a dispute resolution that is within the ground where people are and easily accessible to them. So I think the status of the courts is very clear, and we may say that it is pitched at being a Section 34 rather than it being a Chapter 8. Moving on to the second point, Chairperson, is the issue of legal representation, which I think the department tried to explain as well, and we are hoping that it has definitive clarity. But if the issue is raised as a constitutional right, if it arises out of Section 35(1)(f) of the Constitution, I think having been clear that this is more of a restorative justice system that seeks to bring easy access to people, it is not necessarily an adversary and the conventional criminal justice system where that right, if you are going to be implicated and your rights are going to be further implicated against what the Constitution provides, then it requires that you be given legal representation. But in this context, and as well as considering the implicit nature of the fact that even though the opt-in expression or opt-out was taken out at the other stages of the bill, it is still clear that if we look at Section 30 and 31 of the Constitution, being involved in a cultural life is still a voluntary exercise in one's private life and in the lifestyle that they choose to live where they are. So I think the issue of legal representation together with the issue of opting in and opting out and being made voluntary and expressed in the bill, even though the expression that was giving effect clearly was taken out. If one read the provisions of the bill as they stand, starting from the preamble all the way to the end, especially the guiding principles in clause 3, the guiding principles in clause 3, Chairperson, as well as 4, and the nature of the court, it is very clear that it still comes out that they can still exercise that right in Section 30 and 31 of the Constitution. The fourth issue, Chairperson, is the one that relates to the mechanisms out of the bill that seeks to protect and advance the protection of vulnerable groups that participate in this customary system. Chairperson, I think, as already pointed out in your introduction, the Traditional and Khoisan Leadership Bill, which is now an act in a sense that the president has assented to it. And what is still not having happened is to determine the date when it must commence and come into operation. So if we consider the changes and the proposals that have been effected through that enactment, one must look at Section 36 and 38 read together with section of the Khoisan and Traditional Leadership Act, together with clause 5.3, which is basically calling for the incremental utilization and promotion of participation for women and all the other vulnerable groups. So having said that, my suggestion in terms of moving forward as to what appears in the current clause 5.3 is to maybe look at it and consider, in light of what the department has presented and proposed as well, to consider further whether the inclusion of both the Commission for Gender Equality and the South African Human Rights Commission, as well as the Commission for Cultural and Language Rights, whether in terms of considering how to look at that mechanisms, they cannot, in this bill or in any other manner, there be a provision, Chairperson, that seeks to direct how can they make sure and mandate it in terms of legislation that this happens. And also the inclusion of the minister in the presidency's office responsible for focusing on women, youth, and the disabled persons. The fifth point, Chairperson, I just wanted to add on was the one that related to clause 13.1H, the use of pledge, oath, and affirmation. I think all I wanted to say there is that we need to appreciate the distinction of the definitions and meaning, the ordinary meaning of these words. Because pledge, it speaks to a solemn promise or an undertaking where a person is making on their own without the need of the involvement of any other to give effect to that undertaking. Whereas an oath, it is also a solemn promise, often invoking a divine witness regarding your future conduct. Whereas also affirmation, it does not have the implications of the divine involvement and your future conduct, but it's an affirmation that as of now, when you begin the task, your conduct you are affirming will be aligned with whatever it is that you need to comply with. And then, Chairperson, And then from that number 5, I then move to point 6, which is just the suggestion maybe or a summary of, after having listened to the department and also looked at the provisions themselves, what seems to be the necessary amendments then, and as the members will be deliberating further. I think clause 5, as well as clause 1 on the definition in respect of the reference to the Leadership Framework Act, as well as the new Traditional and Khoisan Leadership Act. We need to look into that. And clause 5, when I explained that mechanism to give effect to the advancement of ensuring that the vulnerable groups are even protected in this system, and the legislation speaks to it. And then the other one, Chairperson, is in clause 3. The clause 3 also, it's related to the new enactment, the Khoisan and Traditional Leadership Act, where we will need to look under clause 6.3 to ensure that there is a reference to the leadership of the Khoisan and the way that it is outlined in the Traditional and Khoisan Leadership Act. As well as clause 11, Chairperson, I think it is necessary for us to look at the cross-referencing, whether the 4.3F that one of the legislatures pointed out was meant to refer rather to 3.3A or to 4.2A or to clause 3.3 broadly in general. So I'm bringing those to the attention of the committee so that when they deliberate and the amendments are prepared in terms of the C list, if that would be the eventual instruction, we are clear as to actually how then and what are the things that need to appear. I also think, Chairperson, for purposes of amendments, we may still also need to look at clause 16 and 17 in terms of the implication of the after consultation and the in consultation. But just to bring an explanation, the in consultation is meant in situations where both parties need to find one another, and there should be no room for stalemate until you find one another. But the after consultation, as the department pointed out, it is the function of the minister, and eventually the minister needs to make the regulations. But consultation would happen should it end up that there's still a stalemate on other issues. The minister then is vested with the final decision to say, this is the position that must go in the regulations. So I think once that is also deliberated and clear, perhaps clause 16 and 17 may require an amendment. I'm not saying that would be the case as yet. But then again, also in terms of clause 16.5a, that one which looks at whether the National House of Traditional Leaders or the MEC is the one who should monitor and deal with the non-compliance of the code. I think the committee would also need to look into that and give us a direction as well. And I think the last one, Chairperson, in terms of the amendments is clause 18. I think clause 18 did not specify, but perhaps the committee may consider. In this bill, are we then repealing or should be repealing the still existing section 12 and section 20 of the Black Administration Act, which was the provisions that were giving effect to the continued existence of the traditional courts, other than when the Constitution came into effect. We were then having the item 16.6 of Schedule 6 of the Constitution. Lastly, Chairperson, I think that the department may perhaps explain to the committee in respect of clause 8.1c, whether what is envisaged there may not, to some degree, or if there is lack of oversight and monitoring, it may not amount to slavery, contrary to section 13 of the Constitution. I think if they may proffer their understanding or view on that. Otherwise, Chairperson, I think those are the inputs I think I thought necessary to make. Thank you.
Thank you, Bumalanga. And we had many lastlies, but thank you very much for that presentation. Our members, I think we've had a very lengthy, elaborate, and yet a necessary presentation from the department in terms of their responses. And Phumelele has also raised quite a few issues, which to some extent, I'm sure the department may also want to respond to. But I think before they even do that, honourable members, let me open it up for deliberations from your side in terms of whether there are issues that you would want to raise, whether it is for clarity or your concerns, especially in terms of the responses that we received from the department in relation to all the issues that were raised by all the provinces. Honourable members, if you can give me an indication in terms of who would want to make any comments. You may use the raise your hand function, or just give an indication if you have anything else to add. Honourable members?
Chairperson?
Yes, ma'am.
Yes, Honorable Barton, just I'm happy with the outcome of the presentations, and for the mere fact that 8 out of 9 provinces support the bill. So I really don't think there's really anything to add except for us to go back and sit down as a committee. Thanks, Chair.
Okay. Any other member? Okay, maybe while you're still gathering your thoughts, I think just from my side, I think in terms of the bill, when it deals with the issue of gender equality and the participation of women, some of these issues were also covered by Phumelele. Obviously, our concern is also around women in rural communities who may also be discriminated against. And I think clause 5, subclause 3B in the bill gives the Commission for Gender Equality the responsibility of monitoring whether gender equality and the participation of women is adhered to in the proceedings of the court. And I think the department's response in the document where the Northern Cape proposes that various categories of vulnerable groups are not included in those listed but by the bill, and recommend that these groups be included in the bill. And the department seems to agree with the proposal, but maybe the department needs to also please expand on the suggestion regarding the addition of vulnerable groups in the bill. Secondly, clause 17 of the bill also speaks to the regulations, and I think in terms of the explanations that also come out of the department, the regulations give effect to the content of the bill, and as well as it will affect implementation. Now, in this regard, what would be the time frame for the department to draft the regulations after the bill is passed? And I think the amendments already that were proposed in the bill by the department deals with alignment to the Traditional and Khoisan Leadership Act, and Phumelele has also touched that. So I suppose, members, if you don't have any objections to those proposed amendments would probably be taken. And I think the other matter that was raised by Phumelele as well, in terms of clause 11, subclause 1A of the bill, which refers to section 4, subsection 3F, which if you look at the bill and you try and go to section 4, subsection 3F, it's not in the bill. So if there's this could possibly just be a drafting error, and perhaps the department can explain if it is such, and obviously it will have to be rectified in the bill. I think that's from my side. Any other member, is there any issue you would want to raise? If not, I take it that you are comfortable with the responses from the department. Let me hand over to Teresa, maybe to just try and respond to some of the issues that were raised by Pumalela and myself. Teresa? Teresa Odingan?
Thank you, Chair. Chair, we've noted the issues raised by the parliamentary legal advisor. I understand them more largely to be comments rather than the what would more interest me more is the areas where we need to re-look for amendment purposes. Let me state from the onset that that reference to 4.3 whatever it's a typo. That is something that just needs to be corrected because I went through it and I could not find that F in the bill, so I knew that that is something that we need to correct. And in some of the areas where she proposed that we need to that amendments needs to be affected are stuff that we've already agreed to, even in our responses. The issue of the pledge vis-a-vis the oath, that has always been a problem, because to start with, it has been argued that it would be difficult to take an oath because an oath has to be taken before a commissioner of oaths. And one can imagine where that functionary would be found in a deep rural area, because those are normally your attorneys and people who have been designated or qualified as such. And I must say, it was the traditional leaders themselves during the consultation process were not amenable to taking the oath. So the taking of the pledge, and also because it is said that the membership of the court changes from time to time. There is no at any given time a composition that you say this is the traditional court, which then makes it easy for the member to make a pledge, because that will just amount to reading the pledge to remind the one of their responsibilities in terms of the bill and the constitution. So that was just some sort of middle ground that was found. With regard to bringing into the bill the other Chapter 9 institution with regard to the monitoring of, with regard to the participation of women and in the courts and the rights of women, Chair, I'm not very sure about that, because I can just imagine, because if the minister has to report to Parliament, and also the commission, the CGE has to report, and Now, with all these other functionaries have to report, my fear that there is that there may be, challenges of inconsistencies, or even just not, proper accountability, other than, and Chair, say even if it were done, the other concern there is that because I remember the CGE itself was concerned of this role being given to them. Now, we consulted at large with them. Now, I'm just raising it that, we will need to go to all these functionaries at this point again to go consult with them. But that is something that we'll need to take it back to the principals and in the department and thresh out.
Teresa, if I may just interject for a moment, my apologies. I think it's not just about women per se, and I think the fact that the Commission for Gender Equality has also been brought into this bill is a progressive issue. Just in terms of also other vulnerable groups, because I think the bill as it stands requires the Department of Justice to put measures in place in order to promote and protect vulnerable persons. And maybe if you could just also unpack what does that actually mean, because maybe it will also become clearer for members. Yeah, thanks. Sorry for the interjection. I'd forgotten that point.
Thank you, Chair. Chair, I understand that it will be necessary to protect or to have some protection for other persons with vulnerabilities under, in this scope. And the thinking, without bringing in the reporting there, let me just say this, was that because the bill envisages a role for paralegals and interns in the traditional courts, so that they can assist the court, particularly in relation to the observance of the Bill of Rights. So that is what we were thinking, just not without bringing the monitoring part of it into the bill, or particularly into clause 5.3. So what the clause envisages for the minister to bring in, to come up with mechanisms for the protection and of women and persons with vulnerabilities. That is more to look at into in the regulations, like for when the court is dealing with these persons with vulnerabilities, this is what should happen, not necessarily having to put that in the bill, but that is what is envisaging. And that takes me to the one question that the chair raised on when does the department aim or what that on the timeline for the regulation? Because initially, in the very initial stages, and also because of the history of this bill, we had envisaged for the bill, for the drafting of the bill and the drafting of the regulations to run parallel. But because of the history of the bill, not without preempting what the bill will look like eventually. That is why the drafting of the regulations has not taken off then. And then the aim is that once we get an idea of when the bill is, what the final bill is going to look like, then we accelerate the preparation of the regulations, because that is something that will also need extensive consultation, because you need to bring in things like, the role of these paralegals, and then the content of the training, and as well as who and what will be trained and on what. So there will be consultation needed, a lot of consultation needed there with both COGTA and the National House, and working with the department. But that is something that we really need to accelerate, because this bill really has a long way coming. There are, other than the areas that I've mentioned, that we have, and we do agree that there will need to be some amendments. With regard to clause 16 and 17, that is, we need to apply our minds there too. It may not take long, because there is just a question of whether the consultation should be after or in, whether the minister making the regulations or taking whatever action in consultation or after consultation. But our view has always been, you see, if you go, like Bumalanga mentioned, if you go in consultation, there, you run a risk of having the process being hamstrung, and that is what we were trying to avoid. And with the regulations, for instance, that is a duty that is placed on the minister. So whether the consultation brings a stalemate or what, the minister will still have to do that, irrespective of the stalemate, because that will be a statutory power that is placed on him. But the consultation, as a matter of course, take place, especially on a subject like this, where it is, a subject of customary law. It's something that, we will need the assistance of the persons with the understanding of how the system works. On the issue of the orders of the courts, with regard to clause 8, 1C, whether that order will not amount to slavery. That has always been an argument chain. But here, because the bill, like Bumalanga has mentioned, it's pitched to be a section 34 type of fora. Therefore, the parties agree. All the parties are interested in the resolution of the dispute, so that at the end of the day, there is social cohesion, there is maintenance of peace in the community. And because in most cases, here we're talking of people in mostly in rural, not necessarily exclusively in rural areas, but mostly in rural areas, where you may find that a person does not even have the means for that compensation. But then where the court orders that the one performs some service in lieu of that compensation, then that the relations of the parties are restored, because that is placed on, on the same 11 as the party having been restored to the position one was in before. And while it was strongly objected to in the first time in the 2008-2012 bill. That was particularly because there were blurred lines there between of what is criminal and what is civil. But in this case, because this is clearly restorative and the parties are also interested, is assumed are interested in restoring their relations. In this case, it was not there was no disagreements around this provision and or about around this type of order. I'm not very clear on what Pumelele said about the repeal of sections 12 and 20 of the Black Administration Act, but that we will need to go back and go through with a fine-tooth comb just to make sure, because the inclusion thereof, those sections have already been repealed and they are just sunset clauses. So it is not necessary that we say they are repealed in this act, because in any case, they've been repealed. And this bill, if it becomes an act, it will then repeal them, wholly and finally. I'm not sure if Dingaan wants to add something, Chair, but yeah, that would be my input. Safe to say, we're going to go through all these the comments with a fine-tooth comb and to make sure that everything is covered. And yeah, thank you, Chair.
Thank you. Dingaan, do you have anything to add? With regard to non-compliance to the code, Teresa, I'm not sure if you covered that. Section 16.5. Hey, Dingaan?
No, what I wanted to just add on is on aspects relating to clause 8, subsection 1, paragraph C, wherein Ms. Pumelele was concerned about the slavery aspect. And I just wanted to bring it to your attention, the fact that during consultations, during the drafting of the bill, it was raised at some point, and there was a rider which was included there to say that such service should be undertaken under the supervision and control of a person or a group of persons identified by the traditional code. And that service should not be provided to the traditional leader. And I remember an example was given to the fact that maybe a service in that regard would be, for example, to the benefit of a common interest in the community. Maybe say, for example, an old age home or something like that, but not for the benefit of the traditional leader. Because at that particular point in time, the concern was raised, say that the traditional leaders were going to abuse the system, and that rider was then put in place to just safeguard that aspect of ensuring that it surely would be for the benefit of none other than the person or the community concerned. That's what I wanted to add. Thank you.
Thank you. Teresa, I'm not sure if you responded to clause 16.5a, non-compliance of the code. But maybe before, Pumelele, were all your issues responded to? I know some of your issues were more comments, especially the first few. Yeah, but maybe
As
could you
Chairperson,
clause 16.5a, are you covered?
Yes.
All right. Okay, thank you very, very much. Members, does any other member want to raise any issues for clarity or has any comment that they'd like to make? Honorable Bartlett has already made a comment. Any other member? I take it that you're comfortable with the responses by the department, and perhaps we can then move forward with the process. I think in terms of the discussions and what has come through the latter discussion, the proposals in the document by the department, especially in terms of the definition of a traditional leader and aligning this to the Traditional and Khoisan Leadership Act. So there's agreement in terms of that definition. Secondly, there's the level of the court of a principal traditional leader in clause 6, subsection 3, which is also an alignment issue with the Traditional and Khoisan Leadership Act. There's clause 11.1a, which must be re-looked at, Teresa, in terms of it being a drafting error or typo. There's clause 16 and 17, which must be looked at, especially in terms of in consultation or after consultation. Then there's the section 12 and 20 of the Black Administration Act, Teresa, and perhaps the comment that Pumelela has also made. My understanding was that these sections were being kept alive till we pass legislation in terms of the Traditional Courts Bill. However, as you've said, I think you go and re-look at this matter. And the issue of the regulations and the urgency thereof, because a lot of matters that also relate to vulnerable groups, and as you've explained, the other measures that the department ensuring putting measures in place will come out clearly in terms of the regulation. So there's that urgency on those matters. I don't know, honourable members, is there any other issue that you feel needs to be looked at by the team before the committee looks at probably a C list of amendments? Honourable members, are we covered?
Yes, Chair, we are covered.
Thank you.
Especially the issues that were raised by provinces, they've been clarified, Chair. All those that we still highlight as issues to be followed up, we expect the department to relook at them before we have our meeting as the committee. We are able to get the feedback. Thank you, Chair.
Thank you, Honourable Nita. Any other member would like to say something? Okay, honourable members, I take that silence is consent. Perhaps let me conclude by just indicating that we've run through the concerns that have been raised by provinces in the functioning of traditional courts. And as has been explained, the current bill before the committee does not seek to establish traditional courts, but seeks to regulate the functioning of these courts in line with the prescripts of the Constitution. And it's therefore important that we satisfied that the courts function in a manner that takes into account the rights of all persons who may utilize such courts. And as we've been discussing, the bill does respond in a manner and addresses gender equality, and we've also been discussing matters of people, vulnerable groups. I think we should also bear in mind, as I've said, that besides the urgency for regulations because it affects the implementation of this bill, there are also a number of issues that are highlighted by the provinces that should also find expression in the regulations. And these regulations, also in terms of the current bill, will also come back to Parliament. And honourable members, just finally, that I think in terms of procedure, we will have the next committee meeting that will then look at a C list of amendments. And I think this list will be compiled by the Office of the State Law Advisor in consultation with the department and obviously with our parliamentary legal advisor as well. And Gershwin would also be quite central to the process. And this should serve in the next meeting of the committee for adoption before it will then be sent to provinces for a final mandate. That being said, honorable members, I know it's been a long and a lengthy process. I have you for 4 more minutes before you all want to go and log into the joint sitting. Let me just thank you for your participation in this process. It has come through the various comments that have come from the various provinces. And I think we will then inform members when the next committee meeting will take place. And obviously provinces will, after that adoption of the C list, then get the document for their final mandates. With that said, honourable members, thank you very much. And let me declare this meeting closed.
Thank you, Chair. I'm still without electricity.
Oh, thank you. Thank you, Honourable Bartlett.